In this session, we're going to focus on several basic estate planning concepts so you can better understand how this process works. Let's begin with you. All of us have an estate because many of us own real property, like your home or other real estate. We all own personal property, like automobiles, clothes, furniture, jewelry, TVs, computers, etc. We also have titled property, like bank and brokerage accounts, stocks, bonds, mutual funds, life insurance, retirement plans, and other financial entities. All of these make up your assets, so we will call this the A component. We all have heirs or beneficiaries. Typically, these are your children, those who you want to receive your assets after you pass. This could also be a charity like your church. So we will call this the B component. The objective of an estate plan then, after our passing, is to make sure A gets to B. Pretty simple. However, there are sometimes conditions. A condition may be a future uncertain event, and if the event happens, something needs to be done. As an example, if one of those beneficiaries were only 12 years old, he would be unable to receive your assets until he reached a certain age, usually 18 or above. Therefore, a provision would need to be made to allow for this. So we will call this the C component. Okay, now we can see that the objective of an estate plan is to get A to B, regardless or taking into consideration C. In our first example of getting A to B, we'll look at what most people do, which is nothing. That's right, 60% of adult Americans do not even have a will. When a person dies, assets need to have a way to transfer to a beneficiary or heir. This way usually works through a will. A will is processed by the probate system. This is usually done in a court regulated by the state. If you do not have a will, the state provides one for you. This is normally a distribution formula that defines who gets what. So assets may go not exactly where you would like. If you have a will listing your personal objectives, it will be used. The typical cost of probate can range from 1 to 8% of the value of the assets being probated, with 3 to 4% very common. This could be several hundred to several thousands of dollars. Additionally, it usually takes several months to complete the probate process before final transfer of your assets. This is not a very cost-effective way to get A to B. Certain assets typically avoid probate, as they transfer by a beneficiary designation. As an example, for a life insurance policy, the proceeds would be distributed directly to your beneficiaries, your children. Other title assets, like a bank account or a brokerage account, can also be set up to go to a beneficiary. Currently, there are 22 states that allow a beneficiary deed, so your house, if in one of these states, could go to your designated beneficiary. Using a beneficiary designation is a much more efficient and cost-effective way to transfer assets to your heirs. However, this does not take into consideration certain beneficiary conditions. We've already mentioned age. Other conditions could be the beneficiary has a physical or mental condition and is receiving government benefits, or the beneficiary is a spendthrift, or may have a substance abuse issue or other problems. One other method that many people use to transfer an asset is joint tenancy with the right of survivorship. This is generally used with couples. When the first person dies, the survivor gets those joint tenant assets. However, you could place the title of an asset in joint tenancy with an adult beneficiary. This seems like a good idea, but really it isn't. Here's why. With joint tenants with right of survivorship, each tenant is considered to own the whole item. Therefore, if the beneficiary has a creditor issue or would get divorced, the whole asset titled in joint tenancy may be lost. Joint tenancy with right of survivorship is potentially very dangerous and should be avoided. Next, we will look at the revocable living trust. For most people, this is normally the preferable way to have assets transferred to a beneficiary. Let's see how the trust works and why this is such a great estate planning tool. When you create a trust, you become the creator. This means you set up the trust and you say how your assets transfer, when they transfer, and who will get your assets. Next, you are the trustee. This means you hold title to the assets that are in your trust. This is why you transfer all your assets into your trust. Your real property, your personal property, and your titled property. Additionally, you are the beneficiary. This simply means you continue to use and enjoy all your assets. Finally, you need to select a successor trustee. This is usually one who will implement your instructions if you become incapacitated or when you die. Normally, adult children are chosen for this position. With a trust, when you die, the successor trustee takes over and follows the instructions to distribute the assets to the beneficiaries. However, if there is a condition, such as the beneficiaries are still minors, the trustee will hold the assets in a holding trust and pay out income from the trust and principal for certain situations, like a college education. Please note, it's the ability to hold assets until some future point in time that allows a trust to be able to handle a future condition that would apply to a beneficiary. Let's take a look now at other conditions that could apply to you and what documents are usually used. First is distribution issues. We've already seen that the revocable trust has the capacity to handle multiple conditions that might arise in the distribution process. Next is incapacitation. Durable powers of attorney are designed to select a person to act on your behalf to make decisions if you become incapacitated. There are two durable powers of attorney. One is designed to select a person to make financial decisions if you cannot, and the other allows a person to make medical decisions if you are incapacitated. If you go into a comatose state with no hope of recovery, a living will or advanced directives can be used to state your wishes about being kept on life support systems. Finally, if you forget or you do not transfer an asset into your trust, the last will, sometimes called a pour-over will direct that any assets you may individually own go to your trust. This allows for all your assets to be distributed to your beneficiaries the way you want. Assets that flow from a will to your trust may be subject to probate. This is why it is important to transfer all your assets into your trust. Now, let's take a look at what you should look for when setting up your estate plan. An appropriate term would be estate plan portfolio. Here's why. The portfolio is a package that includes several documents, information material, and various forms. Your plan will include a revocable living trust. This is perhaps the best vehicle to make sure your assets go to who you want, when you want. That is, A to B. The trust typically provides that all assets can flow directly to a beneficiary or be held, to take into consideration a potential condition C. Durable powers of attorney allow you to select someone to act on your behalf to make financial decisions and medical decisions if a condition would occur where you are unable to do so. Living will and directives allows you to state your choice about the continuation of life support systems if you are in a condition of being in a comatose state. Last will allows you to be sure that all your assets will flow through your trust, thereby taking into consideration the condition that you do not or you forgot to place an asset into your trust. Additionally, there is a certificate of trust. This is a 5-page summary of your trust that you can give to, as an example, your bank, to prove that you have a trust, so they will change the title of your bank account to your trust. Schedules, ledgers, and deeds. These are forms to list who and how your assets are owned that are placed into your trust. Transmittal letters. These are forms that allow you to change the title or beneficiary designation of your assets. Portfolio summary. This is a description of the different sections of your estate plan portfolio. Trustee memorandum. This is a set of instructions that lets your trustee know what to do at the different stages of trust administration. And finally, administrative documents. These are a number of documents to make future trust changes and forms to carry out future trust administrative issues to address any other future conditions that might occur. What's next? Contact the person who sent you here. They can help you gather data to begin your own personal estate plan. They can give you a price quote, and they can help you complete the process.